In contract law, if a party breaches a condition precedent, that is, a fact or event that must occur before another party's performance becomes due, that party's breach generally excuses the other party's performance. But what if one party engages in conduct that prevents the condition from occurring? May the other recover for breach of contract? The Second Circuit considered this question in E. Du Pont de Nemours Powder Company versus Schlottman. E. Du Pont de Nemours Powder Company was a group of explosives manufacturers that produced most of the gunpowder in the United States. In 1908, C Du Pont, as president of the DuPont Company, wished to purchase stock in the Pittsburgh Fuse Manufacturing Company from its president, Charles G. Grubb. Grubb then agreed to sell Fuse Company's stock to the DuPont Company in July of that year. Under the agreement, the DuPont Company agreed to pay Grubb $150,000 of stock in exchange for all of Fuse Company's stock. But before they reached an agreement, DuPont, on behalf of the DuPont Company, wrote Grubb a letter in which it agreed to pay an additional $25,000 if, after 1 year, the Fuse Company plant was worth $175,000. After operating the plant for about 6 months, the DuPont Company sold it to a purchaser, which dismantled it. Subsequently, William Schlottman, Grubb's assignee in interest, sued the DuPont Company in federal district court for breach of contract. Specifically, he argued that the letter between Grubb and DuPont was part of the contract, and that by selling the plant, the DuPont Company wrongfully prevented the condition from occurring. Schlottman also sought $55,000 in damages. This amount was the difference between the $175,000 Grubb would have received had the condition occurred and the stock's market value of $120,000. Following trial, Schlottman moved for a directed verdict, which the court granted. However, the court only awarded Schlottman $25,000 in damages. The DuPont Company appealed to the United States Court of Appeals for the Second Circuit.